Good afternoon, everyone. My name is Ben Marzouk, and I'm Chief Justice of the William Minor Lile Moot Court Board. Welcome to the 82nd Annual William Minor Lile Moot Court Competition. The William Minor Lile Moot Court Competition has a long and storied tradition at the University of Virginia. The Lile competition is in its 82nd year here at UVA, and past winners have included the late Senator Ted Kennedy from the class of '59. The Lile competition, and moot court more generally, are one of the cornerstones of the UVA experience, and an indispensable pillar to one's legal education. The Lile Moot Court Competition honors the memory of William Minor Lile, a law professor for over 40 years and the first dean at this law school. The Lile competition spans 5 rounds of brief writing and oral argument competition on problems provided by the Moot Court Board. The finalists began this competition in the fall of their 2L year with the first round of Lile as one of nearly 250 2L competitors. They advanced to the second round, the round of 64, in the spring of their 2L year, and then were one of the top 8 teams chosen to advance again to the quarterfinal round in the fall of their 3L year. And these 4 competitors have advanced even further to the semifinal round and then again to the final round, which will be held this afternoon. After arguments conclude, the judges will deliberate. Upon return, they will announce the champion of the 82nd Annual Lile Moot Court Competition. I only ask 2 things. 1, that at this point people silence their cell phones before arguments begin. And 2, that as the judges leave to deliberate, everyone remain in their seats. The Moot Court Board will be announcing the results of the second round of the Lile competition for UVA's class of second-year law students. I now would like to introduce Lydia Sama, the presiding justice of the semifinal round, who will introduce the problem, the competitors, and the judges. Thank you.
Thanks, Ben. Good afternoon, and thank you again for joining us for the final round of the 82nd William Minor Lile Moot Court Competition. As Ben said, I have the privilege of introducing the competitors, the judges, and the problem. So, without further ado, first for the competitors. For the appellant, Donald Draper, you will hear from Dan Gocek and Chris Cariello. For the U.S. government, you will hear from Lynzi Archibald and Matt Hanson. The presence of these competitors here today in the final round demonstrates accumulation of 2 years of hard work, intense dedication, and just pure talent. So please join me in congratulating these competitors for making it to the final round. Now for the judges. We are sitting in the 14th Circuit Court of Appeals. We are fortunate to have 3 distinguished federal judges join us here today and take time out of their Saturday to judge our final round. You will hear from Judge Barbara Keenan of the 4th Circuit, Judge Eugene Siler from the 6th Circuit, and Judge David Tatel from the DC Circuit. And now for the problem. This case presents 2 important questions of evidentiary procedure in federal statutory and constitutional law. The appellant, Donald Draper, was convicted of first-degree murder after poisoning his wife, Mrs. Francis. The case depended heavily on the testimony of one individual, his psychotherapist. After the trial, during the sentencing phase, the jury and the judge sentenced him to the death penalty based on hearsay statements brought in by the prosecution. Donald Draper brought in this appeal at the 14th Circuit Court of Appeals, and the court certified 2 questions. The first one is whether the trial court violated Donald Draper's psychotherapist-patient privilege as recognized in Jaffe v. Redmont when it introduced psychotherapist testimony in his case. The second issue is whether the trial court violated Donald Draper's Confrontation Clause rights under the Confrontation Clause of the 6th Amendment when they introduced hearsay statements against him at the sentencing phase. We are really excited about this final round, cannot wait to see what happens, and thank you so much again for joining us.
All rise. The United States Court of Appeals of the 14th Circuit is now in session. The court will now hear arguments in case number 78 CR 969 in Donald Draper v. United States.
You may be seated. You may proceed first for the appellant.
Thank you. I'd like to reserve 2 minutes of my argument time for rebuttal. Your Honor, may it please the court. My name is Dan Gocek, and with Chris Cariello, I am counsel for the appellant, Mr. Donald Draper. I will be addressing the first issue on appeal, which is whether the district court erred in admitting the testimony of Mr. Draper's therapist, Dr. Olson. It did. We request that this court reverse the decision of the district court and bar the admission of Dr. Olson's testimony for 2 reasons. First, Mr. Draper did not constructively waive his right to assert the therapist-patient federal evidentiary privilege. Second, there is no dangerous patient exception to that privilege. Would the court like a brief recitation of the facts?
Well, just briefly for the salient facts, yes.
Well, Your Honor, Mr. Draper was receiving counseling from Dr. Olson, at which time he made a threat to her regarding his ex-wife, that he intended to hurt his ex-wife. Dr. Olson then communicated that threat to his ex-wife, and later on, the ex-wife was unfortunately killed.
But didn't the psychiatrist first advise the Donald Draper that the communication was not confidential?
That's correct.
Okay,
well,
so then you said the first issue you want to talk about is waiver. Jaffe focuses on confidential communications, right?
yeah.
Okay.
Well, it does use the word confidential to describe the communications it
Right.
covers.
Well, isn't that what Jaffe's about? It creates a confidential privilege between psychotherapist and patient, right?
Well, Your Honor, we would argue that the focus of Jaffe is not on confidentiality per se, it's on the expectation of confidentiality of
Okay,
the
but
patient.
my question is that if it's focusing on a confidential communication, if the first thing that the psychiatrist told Donald Draper was that these communications may not be confidential, then why do we have to get to the question of waiver at all? Why does Jaffe even apply?
Well, Your Honor, the reason Jaffe applies is because informing a patient of a terrorist-off duty to warn potential victims does not necessarily inform a patient when specific communications will be divulged and to whom it will be divulged, nor does it...
But don't you think that Donald Draper would have thought that when the doctor said, if you threaten anyone, I may have to communicate it, that, I mean, he had no assurance that communication wouldn't go beyond the threatened person, right? That person might tell someone else, like maybe the police.
Well, Your Honor, that's correct. And under the Lile statute, the therapist was entitled to inform the police. However, we believe that the important aspect of that is that the disclosing that information for the purposes of a terrorist-off warning is based on preventing future harm, whereas testifying in court for the purposes of securing a conviction is aimed at rectifying past harm. And we believe that patients are able to comprehend the difference between disclosure for prevention of harm and disclosure for rectifying past harm.
I don't want to go beyond the record, but having watched Mad Men for many years, I'm sure Donald Draper would have no trouble understanding the difference.
Well, Your Honor, and that may very well have been the case, but we cannot say that that would very well be the case for most patients.
I was trying to help your argument. Doesn't that? I was reinforcing your point.
Oh, okay. Well, thank you, Your Honor.
My question then, sir, is what role then will the psychotherapist have to assume in order to effect a competent waiver from a client such as yours? In other words, what kind of a warning would the therapist have to give to have the warning be voluntary or the waiver be voluntary and knowing?
We believe that the therapist would have to specifically inform the patient that should the patient make a threat that she believes is serious, she will be entitled to testify in court. Here, it does not appear that Mr. Draper was informed of the possibility that she could testify.
So it would be akin to a Miranda warning then, is that correct?
Yes, Your Honor.
So you're be turning psychotherapists into officers of the state, requiring them to give warnings to people, essentially telling them we're your adversary in the event that you tell us anything and decide to tell us anything? Is that really the purpose of the law?
Well, Your Honor, we think the purpose of the law is to ensure that patients do not view their therapists as adversaries.
Right, but I'm concerned about the role of the therapist, and that's the focus of my question here. You're really turning the therapist into a quasi-agent of the state, are you not? By having the therapist have to give certain precise warnings and then a separate determination of voluntariness being made, doesn't this put the therapist in a quasi-governmental role? And wouldn't that be a problem?
Well, Your Honor, we're not necessarily requiring that therapists do inform their patients that they may testify in court. We're simply saying that if they don't say that, then they cannot testify in court.
Right, but isn't the logical corollary of that is that they would have to if they wanted to testify?
Well, yes, it is. However, we believe that therapists do not want to testify against their patients in court because we believe that therapists also view the trust between patients and themselves as important in facilitating proper mental health care.
But you admit that there was a waiver here. You're saying the waiver only has to do with the therapist telling others or the person who's at risk there. Are you admitting that it is a waiver? Or are you saying there is no waiver at all?
We do not believe there's waiver at all. We believe that the Tarasoff warning embodied in the Lile Code is a very limited exception to the general rule of confidentiality between therapists and their patients. We do not believe that Mr. Draper could have waived his right to assert the privilege, the federal evidentiary privilege, because finding that he did so would require that he understood a number of things that we don't believe are reasonable to assume.
So in order to make that determination, a court would then have to conduct a mini trial, would it not, to determine what Mr. Draper knew at the time he made the statement, a questioning of the psychiatrist or psychotherapist at the time the warnings were given? You'd be setting up a construct, wouldn't you, that would require an extensive pretrial determination?
Well, Your Honor, we would instead suggest that a rule be created where it is assumed that if patients are not specifically informed that their therapist may testify in court, that they are not aware of that possibility. Instead of requiring a separate mini trial to determine that, we would argue that it should be assumed that patients do not understand that if they are only given a Tarasoff warning regarding preventing future harms.
Now, for you to win, for you to succeed here, you have to show both that there was no waiver, correct, and that there's no dangerous person exception.
That's correct.
So do you think that Jaffe, do you think that Jaffe requires a dangerous person exception?
We do not believe that Jaffe requires a dangerous patient exception.
So you think we're free as a quote, inferior court to rule that there is no dangerous person exception?
Yes, we do, and both the Sixth and Ninth Circuits have found as much.
And what's your best argument for that?
Well, our best argument is the text of the footnote on which the argument for a dangerous patient exception relies. The text of that footnote is, we do not doubt that there are situations in which the privilege must give way. For example, if a serious threat of harm can be averted only by means of a disclosure by the therapist.
And it says must give way.
It must give way. However, in this situation, there is no harm that can be averted only by means of a disclosure.
Oh, well, then you just answered a different question than I asked. So you think there is a dangerous person exception, but it doesn't apply in this case? I thought you said we could rule that there is no dangerous person exception and never get to that question.
We do not believe a dangerous patient exception exists generally. However, you are correct. What I was just addressing, unfortunately, missed your point. And what I was just saying was that if there is such an exception, it does not apply to this situation. But more generally, we believe that the footnote was specifically referring to the ability, it was specifically making sure that the decision in Jaffe would not be read to foreclose the ability of therapists in relationships with patients governed by federal law from testifying at things such as civil commitment proceedings.
Okay, but if I'm worried that this dangerous patient exception is dangerous to the privilege, you believe that this court would be free to rule that there just isn't one?
Yes,
And if so, how would we justify that? What would we say?
We believe that the footnote in Jaffe was not intended, to begin with, the footnote in Jaffe was dictum. It wasn't meant to create any substantive law. But
Right.
secondly, we believe that the footnote should not be interpreted to establish a broad, dangerous patient exception.
Okay. That tells me why I'm not bound by Jaffe. But tell me why I'm free then to go forward and say, having not been bound, being unbound by Jaffe, or this court would rule that there is no dangerous patient exception. What would we say in support of that?
Well, Your Honor, there are two major reasons that we believe you should rule against a dangerous patient exception. First, we believe that creating a dangerous patient exception would chill therapist-patient communications, and that was the purpose of creating the privilege in Jaffe, to foster that kind of communication and the trust that is necessary in order to have a healthy therapist-patient relationship. Should a dangerous patient exception be created?
But haven't we already done the damage with the Tarasoff? Hasn't that done the damage to the privilege? What additional damage would be done with a dangerous patient exception?
Well, Your Honor, we do not believe that more damage cannot be averted by denying the existence of a dangerous patient exception. Although we acknowledge that patients most likely are not going to be pleased that their potential victims have been informed. At the same time, they are in therapy because they want to get help and because they don't want to hurt anyone.
No, my point's a little different. If I thought that, I mean, what it seems to me that once you've given a Tarasoff warning, doesn't it seem to you that that in and of itself pretty much chills the communication? What more would be added here? I mean, isn't the real problem here the Tarasoff communication? That's what chills the willingness of the patient to fully disclose.
Well, Your Honor,
Isn't it?
while we acknowledge that Tarasoff most likely has some sort of detrimental effect on patient-therapist trust, we believe it's limited by the fact that the disclosure is aimed at preventing future harm, and these patients are voluntarily in therapy, presumably for that purpose, to prevent harm. So while, yes, patients are probably not going to be thrilled that a Tarasoff warning has been delivered, at the same time, we don't believe that would be as damaging as testifying in court in order to secure a conviction against that patient.
How would we answer that question if we wanted to?
Answer what question? Your
That
Honor?
question. How would this court know the answer to that question? Is there any way? There's no record evidence on this question, is there?
Well, Your Honor, we can look to Jaffe, and an explicit assumption underlying that decision was that patients do consider privileges in determining which confidences to divulge to their therapist.
But you don't know if the average patient would even know the difference between waiving the privilege for testifying and waiving the privilege to warn somebody of this danger, right?
That's correct, Your Honor.
That's just speculation.
It may be speculative, Your Honor. However, we need to remember that the purpose of federal evidentiary privileges is to induce certain behavior from those claiming the privilege. And so to assume it works, assuming that patients don't understand the privilege won't help them, it won't help control their behavior, it won't help them, induce them to engage in more therapist relationships, which could help their mental health. We want to look at their expectations and their understanding of their relationship with their therapist. And while they may not completely understand, we believe that if you remove the privilege, the patients are going to have a better idea because therapists ethically are going to be required to tell them that there's no privilege.
The Tarasoff warnings, are those legislative? Are those generally adopted by, I know in this state it's legislature, right?
In some states, it's legislative.
Do you know whether any court has ruled whether the Tarasoff warning violates Jaffe?
We have not. I have not encountered any cases that state as much, and we actually believe that the footnote in Jaffe was specifically aimed at ensuring that no one read Jaffe to trample Tarasoff duties.
Didn't Tarasoff exist at the time?
It did exist at the time.
Did footnote 19 cite Tarasoff?
It didn't specifically cite Tarasoff. However, in saying if a serious threat of harm can be averted only by means of a disclosure by the therapist, those words are found in almost every terrace-off duty. And so it seems more than coincidence that the court would use those exact words in that footnote if they weren't specifically referencing terrace-off duties generally.
So you're requiring that a waiver be knowing and voluntary to exist, is that correct?
Yes.
How does a court go about determining that when the court is in a position of having an individual who purportedly gave that waiver being in an extreme state of mental agitation anyway, at the time he or she was seeking out the psychiatrist? So I'm getting, I guess, back to my mini trial question. It seems to me we've got an even bigger problem, because not only are you going to have the therapist having to testify in this mini trial, you're going to have the defendant testify, arguably, or in this mini trial, but you're also maybe going to have other doctors testify as to their previous association with this defendant. You see what I'm saying? How do we keep this from spiraling out of control?
Well, Your Honor, I see my time has expired. May I have leave to answer the question? We believe that a blanket rule stating that patients who have not been specifically informed of a therapist's ability to testify at trial must be assumed not to understand as much would thereby negate any need for such mini trials and would create the assumption that unless they're told as much, they could not have constructively waived the right to assert the privilege. Thank you.
Thank you.
Your Honors, may it please the Court, my name is Chris Cariello, and along with Mr. Gocek, I'm counsel for the appellant, Mr. Donald Draper. The second issue on appeal concerns the constitutional guarantees to which a criminal defendant is entitled when the government seeks the death penalty. For two reasons, this Court should reverse the district court's ruling that the Sixth Amendment's Confrontation Clause does not apply to the penalty phase of the Federal Death Penalty Act. First, the Supreme Court's decisions in Appellant v. New Jersey and Ring v. Arizona established that the Sixth Amendment, and by extension the Confrontation Clause, apply to the penalty phase of the FDPA.
Are you saying that it should apply in capital cases as well as non-capital cases?
Your Honor, we are only addressing capital cases here. We are only suggesting that under the Federal Death Penalty Act and under the sentencing procedures laid out in sections 3591 through 3593, the Confrontation Clause must apply.
Is that because the Supreme Court has said that death is different?
It's not because the Supreme Court has said that.
Then you have to lose, because if it isn't for that reason, then Judge Siler's question is a problem for you, because we would have to extend the Confrontation Clause to all sentencing.
Your Honor, I don't think that's true, and the reason for that is Apprendi v. New Jersey. Apprendi v. New Jersey held that any fact upon which a greater statutory maximum sentence is conditioned must be proved to a jury beyond a reasonable doubt. The rationale behind that decision being that they are essentially elements; they're effectively
Exactly.
elements,
Right.
And so in the federal
that's not
context,
the issue in this case.
In this case, the statutory aggravating factors laid out in the Federal Death Penalty Act are those sort of Apprendi factors,
Right.
whereas a sentencing factor in a non-capital case is not.
I know, but weren't these, the issue here, the evidence that you're worried about was introduced to support the non-statutory factors.
Your Honor, while that's true, it was introduced at a proceeding for the same jury while the statutory aggravating factors, effectively elements of a crime under Apprendi, were being decided. I think another way to look at it is imagine some other element of the crime, some essential building block upon which the government exposes a defendant to a statutory maximum is substituted out and proved alongside a non-statutory aggravating factor. Say the requisite mens rea, malice aforethought, is attempted to be proved in something called a penalty proceeding.
In this state, what are the eligibility factors that a jury must find?
The jury must find one eligibility factor from a long list of factors unanimously. In this particular case, those factors were substantial planning and premeditation and exposure of a grave risk of harm to others, knowing exposure of a grave risk of harm to others. So Your Honor...
The grave risk of harm to others, does that encompass future dangerousness as well?
No, Your Honor. I believe it's contemplating that in the same conduct that caused the death of the victim, that conduct could have jeopardized the life of another individual there at the time. The reason that even though some of the evidence seems to go exclusively to the non-statutory aggravating factors, admitting it in this case is still constitutionally infirm, is because the jury could have considered that evidence when resolving the statutory aggravating factors.
So is your argument then limited to a situation where the qualification and selection questions are handled simultaneously? In other words, suppose there had been two, am I right? Some courts have two phases, right? They do qualification, then they do selection, correct?
Yes, Your Honor.
So is your argument limited to a situation where it's done in the same proceeding?
Your Honor, that is the procedure that the Federal Death Penalty Act appears to authorize. So yes, the argument per se is limited to the same unitary proceeding of eligibility and selection.
Don't you think that's a little odd that that a clause of the Constitution, its applicability would turn? So you got the identical issue in both phases, whether it's separate or together. Yet whether the Confrontation Clause applies depends on whether they're done separately or not. I mean, I can't imagine any situation in constitutional law where the applicability of a constitutional protection turns on such a subtle procedural consequence.
Well, Your Honor, first, I think that there is a very strong argument that the Confrontation Clause could apply all the way through to judgment. I think there's a textual and historical argument that that is the case.
You mean all the way through to sentencing?
All the way through sentencing until final judgment. I think the word prosecutions, in all prosecutions, easily embraces extending the Confrontation Clause that far.
What do you do with Williams? Williams has never been overruled.
You're right, Your Honor, and Williams is a due process case. But
Right,
Williams,
but the due process clause still applies.
Williams does suggest that even if the Confrontation Clause does not apply to sentence selection, there is a sort of due process floor. And you're correct in saying that Williams also seems to establish something of a due process ceiling for what matters in the sentence selection phase. But while that's true, what Williams addressed was a separate proceeding. So in Williams, the court actually said, quote, that separating sentencing from the guilt is designed to prevent tribunals concerned solely with the issue of guilt from being influenced to convict for that offense by the evidence that the defendant habitually engaged in other misconduct, end quote. And that's exactly the problem that's presented by trying statutory aggravating factors right alongside non-statutory aggravating factors, because it risks that the jury is going to go back in that room and find an essential element that's required to be proven by the government in order to even expose the defendant to the penalty, while also thinking of certain evidence that should have been subject to the strictures of the Confrontation Clause.
But we've got a pretty careful jury here. This jury only found 2 of the 3 statutory factors. It was able to distinguish between, it understood its charge carefully, and if it understood that, why couldn't it understand that, this evidence, these 3 affidavits, were relevant only to the non? In other words, a jury that was able to distinguish between 2 of the 3 statutory factors should be perfectly capable of distinguishing between the fact that it could use these affidavits only for the non-statutory factors.
Your Honor, it may be the case that there are some juries who can understand that.
Well, we can't do it jury by jury. We ask the reasonable jury question. And my point here is that you've got a jury that seemed pretty capable. So.
It's certainly possible that this jury did not make a constitutional error, but in this context, and I think this is where what Your Honor referenced earlier, that death is different, comes in. The Supreme Court has said death is different in severity and finality. It's said.
You have to give us a practical argument, though. Don't you have to tell us exactly, with regard to the evidence that you allege is improperly admitted, tell us exactly how that improperly affected the eligibility determination in terms of what the jury ultimately concluded? I haven't heard that from you yet.
Your Honor, statutory aggravating factors must be proven unanimously. What this argument amounts to is a harmless error argument. In the constitutional context, the government would have to show that for the error to be harmless, beyond a reasonable doubt, none of those reasonable jurors could have concluded, absent admission of that evidence that violated the Confrontation Clause, that the statutory aggravating factors were not found. And I think that's a very difficult case to make. In my view, a jury going back into a room to consider statutory aggravating factors, while at the same time having information like a plea from the victim's family saying, please make him pay, like two affidavits meant to insinuate that the defendant had committed.
I think maybe you missed the question, though. What factors that were found in this case were arguably influenced by the evidence that you are alleging was improperly admitted?
I think substantial premeditation and planning could have been influenced. And
Okay, walk us through that.
So a juror could have thought that there was no substantial premeditation and planning present, or could have thought that there was no grave risk of injury to others present.
Okay, and
But-
what, the evidence that you're objecting to that should not have been admitted, what evidence improperly was probative of that issue?
Your Honor, none of the evidence was probative, but what it did do is inject an element of caprice and emotion into the process. And caprice
Don't
and
you think a lot more caprice and emotion would have been introduced if Betty's father had actually testified?
Your Honor,
Which is what you seem to want.
Your Honor, it's certainly possible. But
Possible? I mean, think about it. I mean, if Betty's father had been there and had testified in front of the jury to what he said in his affidavit, first of all, can you imagine any defense counsel even considering cross-examining him?
Your Honor, even if we concede that to be the case, even if we concede that defense counsel wouldn't have done this, the Supreme Court in Crawford established that the Confrontation Clause is not a substantive guarantee. It is a procedural guarantee. And there's no want of prejudice that will cure that. The Supreme Court has said so.
Well, that's totally true. You're absolutely right about that. But I was asking you a different kind of question here, which is a practical one, which is just looking at this case. It seems to me it would have been a lot more damaging and a lot more emotional if Betty's dad had testified in person. Because your argument, at least this part, with respect to the father's testimony, turns on the emotional impact this has on the jury. And I assume by that you meant that, you know, if he was subject to cross-examination, it would have reduced that. But it just seems to me that it would have increased it and harmed the defendant more.
Well, Your Honor, you don't need to find each piece of this evidence inadmissible. So even conceding that, a reasonable juror still could have whatever level of caprice and emotion was injected into the process by this victim witness impact evidence could still have returned to deliberations and not come up and not allowed that evidence to influence the finding of the statutory aggravating factors.
What's your best appellate court decision that says the Confrontation Clause applies during the sentencing process?
Profit versus Wainwright from the 11th Circuit applied the Confrontation Clause largely for reasons of the court's death as a different jurisprudence to the entirety of capital sentencing, distinguishing between capital and non-capital sentencing, as I said, mostly for the reason that the severity and finality in the death context is different. But as I was suggesting, the evidence, the affidavits of Mr. Romano and Mr. Phillips are highly prejudicial. They were not subject to cross-examination, which is meant to test the narrative capacities, meant to test perception, narration, sincerity. And the fact that they were not subjected could very well have led a jury to consider those facts in thinking about, is this the sort of individual who premeditates and plans? Is this the sort of individual who may have some experience? And as the Williams court said, this is the reason that sentencing is separated from guilt factors.
I think that's a very strong argument, but I'm curious why you've chosen to raise it in the Confrontation Clause context, which raises extremely difficult constitutional questions, when you could have made exactly the same point by relying on that provision of the Act, which allows the exclusion of evidence whose probative value is outweighed by its prejudicial effect. That's right in the statute, right?
Yes, Your Honor, that
The
is.
statute would have authorized the district court to have excluded this evidence because of, as you said, its deeply prejudicial effect.
Yes, Your Honor, and the
you
reason.
could win this case that way without asking this court to step into these very complicated constitutional questions.
Well, then we would have to ask this court to cabin in some important sense the district court's discretion under that particular substantive rule that
Isn't
looked.
that what the district court's supposed to do every day when it conducts trials? It's supposed to make those calls, right?
Absolutely, Your Honor,
So
except
why would that be cabining?
well,
It's asking the district court to do its job, isn't it?
well, if Your Honors were to decide on that on the grounds that the statute was violated because the evidence was probative, though that issue is not certified for appeal, I think appellant would be very happy with that result.
Well, of course you would, but my question was, did you raise, see, the point is that courts are very good at this question of balancing probative value against the prejudicial effect. We do it under Rule 403 all the time.
Yes, Your Honor.
Well, that was my question.
Yes, Your Honor, absolutely, and I think it's certainly possible the district court did faithfully balance and come to a conclusion that it thought was correct, but that doesn't change the fact that the Confrontation Clause exists, and the Confrontation Clause is a procedural guarantee. It's a constitutional guarantee, and as the court in Crawford said, when we subject these sorts of constitutional guarantees to a sort of open-ended balancing, we do violence to their design. And I think that's exactly why the Confrontation Clause is important in this context, and exactly why we're suggesting the Confrontation Clause should apply. The fact is that when the government seeks the death penalty, there are heightened concerns. It's the gravest use of power that the government can undertake. And they should be held to higher standards, especially constitutional standards. In this context, the Confrontation Clause could have been applied. None of the declarants were unavailable. They easily could have, with minimal extra burden, appeared in court and been subjected to the sort of trial procedure that's been embedded in the Constitution and has been a bedrock principle for criminal law for a very long time.
In your brief, you make a heavy argument based on the text of the Sixth Amendment.
Yes, Your Honor.
But the government points out that the Sixth Amendment says, in all criminal prosecutions, the accused shall enjoy, ... the right to be confronted by the witnesses against them. And Don Draper is no longer an accused.
Your Honor, I'm out of time. May I have leave to conclude? To answer your question?
Chief Judge. Yes, of course.
Thank you. The accused convicted distinction falls away when Apprendi is considered. Mr. Draper has not gone from accused to convicted in the relevant sense before the statutory aggravating factors have been established and he's become eligible for the relevant punishment.
You mean Apprendi couldn't have come out the way it did if accused plays the role in it that the government says it does?
Yes, Your Honor, that Apprendi would control that. For the foregoing reasons, we request that this court reverse the district court and vacate the sentence. Thank you.
Thank you. You may proceed on behalf of the government.
Thank you, Your Honors. Ladies and gentlemen, Your Honors, opposing counsel, good afternoon and may it please the court. My name is Lynzi Archibald and I, along with my co-counsel Matt Hanson, represent the appellee in this case, the United States of America. I will be addressing the first issue, the admissibility of testimony by the appellant's therapist, and my co-counsel will be addressing the second issue, the admissibility of affidavits during capital sentencing. This court should find that the appellant's therapist's testimony was properly admitted by the trial court for two reasons. First, the therapist's testimony is subject to the dangerous patient exception of the psychotherapist-patient privilege as established under Jaffe and supported by public policy. Second, the appellant's statements to his therapist were not confidential and therefore they were not privileged.
Go ahead. I'm saying, did the district court below rule on both those sub-issues or just on the waiver?
The district court below just ruled on the waiver issue, but we would like to ask this court to also find that there is a dangerous patient exception today.
And I'm curious about why you only have to win on one of these, right?
Yes, Your Honor.
Okay, so I'm curious about why, I had this question when I read your brief, and it's reinforced now by hearing your oral argument. You begin with the dangerous patient exception, right?
Yes, Your Honor.
Is that because you think that's the stronger of the two arguments?
Not necessarily, Your Honor. The dangerous patient exception is cabined in Jaffe by the Supreme Court, and also it was the first issue to be addressed by the district court, so that was why I began with it in my brief. But I can start there if
No,
you'd
you can
like.
start wherever you want. The reason I asked the
Okay.
question is it just seems to me that, you know, as best, excuse me, as best I can tell, 2 of the 3 circuits that have considered it have rejected it, right? And as I understand it also from the defendant's brief, most of the states that authorize tariff exceptions don't adopt this, right?
Well, Your Honor,
Because it just seems such, you know, an extreme departure from footnote 19 to argue that the dangerous patient exception applies in a situation where there's no longer any danger.
well, Your Honor, I have a few ways to address your question. First of all, it is true that both the 6th and 9th Circuit decided not to adopt the dangerous patient exception and that the 10th Circuit did. However, the remainder of the circuits haven't addressed the question. And furthermore, though most states do not have a dangerous patient exception written into statute, many of them haven't considered the issue yet. There are a number of reasons why the
Well, the reason I asked the question, though, is we're talking about a privilege here, right?
Yes, Your Honor.
Rule 501, and we look to experience. And one of the things we look to is the experience of the federal and state courts. And if no one's adopted it, right?
Well, the 10th Circuit has adopted it, and furthermore, as Judge Kleinfeld in his concurrence for the 9th Circuit in Chase pointed out, the Supreme Court's dictum should speak even more persuasively than usual because dictum or not, what the court says reflects its reason and experience.
Okay, but the Supreme Court's dictum went only to threats, a serious threat of harm and averting harm,
Well-
averting future harm. There's nothing in this footnote 19 that addresses after the fact
Yes, Your Honor, but
testimony. And so how can you rely on Jaffe? Jaffe's pointing to the future. It's not saying anything about testifying about past events.
well, Your Honor, but it does say something important in saying that the privilege must give way. Though opposing counsel has said that this must be stating something about commitment proceedings or stating something about tariff warnings, it's important to know that neither in the Jaffe footnote nor anywhere else in the Jaffe opinion does the court talk about commitment proceedings or talk about tariff
Okay,
warnings.
let's say, let me ask you one of my favorite questions I like to ask lawyers.
Yes, Your
You're
Honor.
writing the opinion of this court. What is the rationale? You're trying to go from the Jaffe footnote number 19 to a dangerous patient exception that has nothing to do, or not necessarily anything to do, with averting future harm. So what are you going to say as the opinion of this court for the rationale for adopting it if it is not limited to averting future harm?
Your Honor, I would write the opinion with 2 major supports to my argument. First of all, that the Jaffe footnote supports adopting such an exception because it identifies that there are times where the privilege must give way. Even though it doesn't say that this is the specific case, it does provide support. But second of all, this
But
court...
it says, if a serious threat of harm to the patient or to others can be averted.
Yes, Your Honor.
Does that apply in this case?
It does in some sense, and this leads me to my public policy reasons for adopting a dangerous patient exception, though it has been claimed that our only reason to adopt such an exception would be to get more convictions. That is simply not the case. For example, in addressing protection, as you brought up, Your Honor, continued protection sometimes will only be solved by the incarceration of someone who is dangerous and guilty of committing a crime. Though Mr. Draper has been found guilty of this crime, and though, unfortunately, his victim was successfully murdered, if he is not convicted, he can still pose a very serious danger to other people.
Well, that's not the question in this case. He has been convicted.
Well, Your Honor, it's not that he has been convicted that I'm arguing. I'm saying that the public policy reasons for adopting such an exception, which should be considered in order for this court to determine the exception in light of its reason and experience, include continued danger to others. For example, though...
So you're relying on, in response to my earlier question, you cited Judge Kleinfeld.
Yes, Your
right?
Honor.
Who, I think in the same case, also said, in any trial, little can be more important than that the verdict be true.
Yes, Your Honor.
You embrace that also?
Yes, Your Honor.
What do you do with things like the exclusionary rule? I mean, this isn't the way our judicial system works. It isn't the case that little can be more important than that the verdict be true.
Yes, there are many reasons
We have
why...
many fundamental exceptions to that.
Yes, there
And
are.
maybe this is one of them. Maybe this is a situation where society has decided that the value of effective psychiatric therapy is more important than the outcome of a particular case, more important to society.
Yes, and that's the balancing test that this court has to go through, but it's not just the mental health of the patient that has to be weighed. For example, we have to compare the mental health of the patient above and beyond after the tear-off duty has already been fulfilled. We're not talking about the damage to the therapist-patient relationship before any disclosure has been made. This case deals with once the disclosure has been made and actually mandated by the state statutes to disclose both to the law enforcement agencies and to the potential victim, what additional harm is going to happen to the patient-therapist relationship if the therapist is then allowed to testify in court.
Well, that's a big difference, though. I mean, it's one thing to say that I'm going to have to report you, a general comment like that, and then the patient keeps talking without any knowledge that the therapist is going to essentially be parroting back his or her statements on the witness stand in front of a jury. That's a huge difference, isn't it?
It is different in some sense, Your Honor, but at the same time, these therapists are allowed to testify at civil commitment proceedings, which would result in the same result of having the
Right,
patient.
civil commitment proceedings are a lot different. They're very limited in time. And if a person is involuntarily committed, what is Jackson, is Jackson rule still 6 months? I'm not sure. Before it has to be reviewed. It's extremely different than a death penalty sentence being imposed.
Yeah, it is different on a number of levels, but also you have to consider the therapist can reveal this information to the police, and that could result in the police knowing where to go at the right time, knowing who to ask for evidence, a bunch of other results that would eventually possibly lead to his conviction in the same way that testimony would by the therapist herself. So when we're weighing...
Could, but not necessarily.
Not necessarily.
It sounds to me like you're just looking for another tool for the prosecution tool bag, another way to convict a person.
Your Honor, we are looking for another way to ensure that justice is done, and there's a number of other things that support this on the public policy grounds. As you brought up, Judge Tatel, the truth is essentially important. As stated by the Supreme Court in U.S. v. Nixon, privileges are not lightly created nor expansively construed, for they are in derogation of the search for the truth. Furthermore, one of the four purposes of punishment, as stated by the Supreme Court, is retribution, which would be denied to the victim and their families if these people are not brought to justice because such statements won't be...
That's a really good point. And I think that crystallizes the issue here perfectly for us. So when we're trying to figure this out, are we looking at it that way? That is, how do we do justice for the victim of that crime? Or the other way to look at it is the defendant says in his brief that to allow a dangerous patient exception here would mean that people with mental disorders would be less likely to get psychiatric help and therefore be more dangerous to society as a whole. So the balance is, and that's what we do under Rule 501, right? We're common law courts here. We're balancing these various values, and so what do you tell us about that? About how to look at it that way? Which one is it? Why shouldn't I look at it the way the defendant asked me to, which is from society's perspective, and that society will be safer if we ensure that people with mental disorders, particularly dangerous people, get the maximum amount of psychiatric therapy?
Yes, Your Honor, that's a good question. That's something that both the Sixth and the Ninth Circuit addressed in their opinions that rejected the dangerous patient exception, citing the fact that people need mental health therapy if they are dangerous more than ever.
Right.
However, both courts cited only one study, a study by Greg Long in 1992, that basically stated that people will be less likely to go to their therapist if the privilege is taken away. However, many more recent studies have stated that this is a fear that has not materialized and will not materialize. For example, when the Supreme Court of California ruled on Tarasoff, many psychiatrists said this will have a substantial chilling effect on people seeking therapy. But that threat was never realized in that case, and it wouldn't be in this case either. I would point to, in my brief, I cited Alicia Klinka, It's Been a Privilege, who stated that upon examining a few studies on this issue, it seems very unlikely that privilege or lack of privilege deters patients from seeking treatment.
So then maybe Jaffe's wrong.
Your Honor?
Maybe Jaffe's wrong.
Well, Jaffe doesn't concern the warnings per se, it just
No, but
concerns...
according to what you're saying, you don't even need a privilege here.
I'm sorry?
That a privilege is just irrelevant, right?
No, the privilege is extremely relevant, but this is a very specific case where a threat has been made about a particular individual that the defendant would have the intent and the ability to carry out. And
Except that it's over.
yes, Your Honor, but it's not over in the sense that the defendant needs to be brought to justice. We need to have
Well,
maximum.
maybe if the police here had found additional evidence, instead of relying on just one witness, they could have easily brought this defendant to justice without breaching the privilege here.
Yes, and based on the record, there was a lack of fingerprints and other evidence, but certainly potential criminals shouldn't be rewarded for being able to cover their tracks well when there is available evidence through the therapist's testimony.
Under your theory, this Tarasoff warning is not necessary if there's a dangerous patient exception, right?
No, Your Honor, the Tarasoff warning would still be necessary in order to protect the victim at that very moment, but for continued protection and for the purposes of truth and justice, the dangerous patient exception to the testimonial privilege would be required as well. As I see that my time is running out, I'd like to turn to my second point, which is that the defendant in this case could not have a reasonable expectation that his communications would remain confidential, and therefore under Jaffe they cannot be privileged. As the court stated in Jaffe, the privilege covers confidential communications made to licensed psychiatrists and psychologists. The defendant in this case had no reasonable expectation of confidentiality because the therapist told him that his statements would be revealed to third parties.
Well, wait, not third parties. It would only be revealed if he threatened. I mean, if he had done that, if that had been what the patient would say, you'd be absolutely right. But that isn't what the psychiatrist said here.
Well,
The psychiatrist said that if you threaten someone, I will have to either warn that person or the police or both.
yes, and
That's very different than saying if you threaten someone and are convicted, I will testify against you.
Yes, it is different, but that distinguishing factor of whether it's court or whether it's the Tarasoff warning isn't what the Jaffe court is talking about. They simply say that the privilege covers confidential information. And once that confidentiality is broken, it is broken forever. As you brought up in my opposing counsel's argument, the police and the potential victim have absolutely no duty not to disclose this information to other people. In layman's terms, the cat is out of the bag once the psychotherapist has revealed it to anyone, and therefore confidentiality no longer exists. This was pointed out by the Fifth Circuit in Oster in 2008, which stated that the Jaffe decision unambiguously limited the privilege's applicability to those instances in which the patient's statement was made in confidence. And because the patient knew that his statements would not remain confidential if he made a threat, then those threats...
Except that it was, I know, except that it was a limited statement in the Tarasoff situation. It wasn't that, presumably the patient understood what the patient was told. That is, that it would be disclosed for a certain reason. And that is not, and there's nothing in that I cannot imagine that a patient would think from that means that he's freeing his doctor to testify against him in court. It's a totally different situation, isn't it?
Your Honor, I see that my time has run out. May I
May respond.
Okay, thank you. It is a slightly different situation, but we aren't talking about the rules of confidentiality. We're talking about the rules of privilege. So if we were talking about a waiver situation, the patient would have to knowingly, voluntarily, and intelligently waive his right to privilege. But this is not that case because the privilege simply does not apply because the statements were not confidential from the beginning. It is for the foregoing reasons that the appellee respectfully requests that this court find the testimony by the appellant's therapist was properly admitted by the trial court. Thank you.
May further proceed for the government.
Good afternoon, Your Honors, Counsel, and may it please the Court. My name is Matthew Hanson. I also represent the United States in this case, and I'll be addressing the affidavits at capital sentencing. Quite simply, Your Honors, this is a case about a convicted murderer looking for a procedural out to avoid his sentence. This court should reject this attempted end around, and it should do so for at least 3 reasons.
I guess that could have been,
Procedural, excuse me.
you go.
What do you mean by procedural out? Are you talking about rights or? It seems to me you're starting off on a very difficult point there, Counsel.
Yes.
I don't know that you need to say that in order to make your case. You may want to consider that.
Okay, sure. Just to summarize what I'm saying there, the appellant is looking to establish constitutional rights in a place that the Supreme Court has not recognized those rights in any case.
Couldn't you make that argument in Gideon, Miranda, 10 other important constitutional cases?
Well, specifically, Your Honor, I focus on Williams. And so the fact of the matter is that since 1949, the Supreme Court has held directly in Williams that there is no right to confrontation in capital sentencing.
What's changed since Williams? I mean, you've had so many different cases, and I think that's what Judge Tatel was
Yeah,
saying.
Williams is pre-confrontation, pre-death is different, pre-Apprendi.
Correct, Your
This
Honor.
is a very different world we live in today.
It is, Your Honor, and the Supreme Court has approached the issue time and again and has never overturned Williams. In fact, Williams has become sort of a bedrock of the criminal law jurisprudence. It's one of the cases that the Supreme Court has time and again declined to overrule. Marbury versus Madison was decided 200 years ago, but just because many cases have been considered since then doesn't mean that that case should be overruled. But even the procedural facts...
Do you think we have to overrule Williams to be able to rule for the defendant in this case?
Your Honor,
Really?
yes.
Why? Well, it's a due process case. This is a Confrontation Clause question.
Right, and you're right to point out that Williams was pled under a theory of due process. However, the reason that it was pled under due process is because the Confrontation Clause was not incorporated against the states until Poynter in 1965.
Precisely my point. That's why we don't have to overrule Williams. But we can't overrule Williams. We're just a circuit court.
Correct.
But we can rule for the defendant without running afoul of Williams. That's my point.
Why can't we distinguish Williams on the basis that it wasn't addressing the Confrontation Clause?
Because the facts of Williams apply too closely to the case at hand. In Williams, the sentencer there, judge, looked at hearsay evidence for purely selection part of sentencing and ruled that that was the evidence that had him choose to select the death penalty. That's exactly what happened here.
Apprendi overrules Williams, at least with respect to statutory factors.
But importantly, Your Honor, Apprendi did not bring up the issue of the Confrontation Clause. Neither did Ring, neither did Booker or Blakely. We're here to talk about the Confrontation Clause.
No, but in view of Apprendi.
How so, Your Honor?
Yeah, right?
How so?
Well, Apprendi says that the jury has to, in other words, how, doesn't, for purposes of Confrontation Clause analysis, doesn't Apprendi undermine Williams?
The United States will grant that in Apprendi, in Booker and Ring, the Supreme Court has started to carve out a sort of a gray area between the end of trial and pure sentencing, this discretionary selection phase of sentencing. However, importantly, the Supreme Court, again, did not address the Confrontation Clause in Ring or Apprendi. Ring has to be understood in relief with Harris, which was also decided the same day, in which the Supreme Court said that when a sentencer is selecting from a range of punishments for which the defendant is already judged eligible, that sentencer may consider any range of facts that have not been proven to a jury beyond a reasonable doubt.
Let me ask you this. Is it your position that the Confrontation Clause doesn't even apply to statutory factors?
Again, it's clear that the Supreme Court has created sort of a gray area there, but to the extent that the appellant argues that that practical concerns of policing the line between eligibility and sentencing argue in favor of just pushing confrontation rights all the way through sentencing, then the United States would definitely argue that this court should keep Confrontation Clause rights completely out of sentencing.
Well, how can we do that consistent with Apprendi? That's what I don't understand. If the statutory factors have to be proven to a jury beyond reasonable doubt,
Mm-hmm.
it just seems
Well, again, so
preposterous to me that that wouldn't carry Confrontation Clause rights with it.
So perhaps it's important to focus tightly on Ring and Harris. With the understanding that when the Supreme Court considers Sixth Amendment rights, the Supreme Court's jurisprudence has not been to import all of the Sixth Amendment rights wholesale into a completely new part of trial or sentencing. They're addressed one by one. And in Ring, the Supreme Court said that these sentencing factors had to be proven to a jury beyond a reasonable doubt, extended the jury determination part. Importantly, did not address the Confrontation Clause.
Correct, but doesn't the logic of the case bring us there? That's my only point. I agree with you, you do it step by step. You're totally right about that. And just because you carry one constitutional protection doesn't mean you carry them all. But if the logic requires it.
So another point on Ring is that Ring did not move all of the eligibility factors back into trial. So there are clearly statutory aggravating factors that do not belong in trial. For example,
Some of them are outside of the trial, but just because they're outside of the guilt determination process, they're still part of the trial. In other words, the sentencing is still part of the trial, is it not? And it seems to me that what you're trying to do is to move us away and to suggest that because it's sentencing, it's not a trial.
that's correct, Your Honor. That's correct.
Right, but you still have the issues that Judge Tatel's talking about, and you still have the problem of Crawford. I mean, I haven't heard you say anything about why Crawford doesn't create a problem for you.
Right. So I'll address your question about Crawford. So Crawford specifically applies to trial. Crawford never said anything about how confrontation rights should apply at sentencing. Clearly,
why would Crawford have to apply to the eligibility determinations? And I think this is what Judge Tatel was driving at. Why wouldn't it have to apply? Because it's exactly the same kind of factual determination that is being made, and in fact is being made to determine whether someone should die. How can it not logically apply?
well, Your Honor, sentencing, since the Sixth Amendment was written, has dealt with factual determinations. And the fact of the matter is that the Supreme Court has, for decades upon decades, understood trial and sentencing to be separate. Now, with Ring,
now that the Death Penalty Act permits and requires these factual findings by a jury in the context of the sentencing, why isn't that old construct now obsolete, and necessarily Confrontation Clause protections go into the sentencing process?
well, Your Honor, the Supreme Court never said that the statutory aggravating factors had to be recodified as elements of the
Factual
crime.
determinations, aren't you? Don't you?
What's that?
You agree that the statutory aggravating factors have factual components.
Absolutely, Your Honor. But importantly, the affidavits that are being challenged here did not go to eligibility. So I want to be clear as we talk about where this court should draw the line. Should it put the maintain that Confrontation Clause rights don't go through past conviction of a capital offender, or whether they might go through statutory aggravating factors. So clearly, they don't go to selection.
Maybe he's a planner. I mean, if this guy's carrying bodies wrapped in carpets down the street, he apparently thought about how to commit crimes and get away with things. Why couldn't a jury have taken that fact of Mr. Romano's testimony and said, this guy's a planner?
But Your Honor,
Don't just, take a rug with you to the scene of a murder, gentlemen. I mean,
Right. But the substantial premeditation statutory aggravating factor relates to this particular crime, and so nothing about those affidavits dealt anything with the facts of the murder for which he was convicted.
Right, but don't you think look, this was a really closely divided jury. We know that. First of all, they found a whole series of mitigating factors, plus you needed an Allen charge, right?
That's correct.
So even though these three affidavits were not submitted for purposes of eligibility for the death penalty, right? Isn't there a really serious likelihood that the jury may have considered them for that purpose?
Well, Your Honor, as you were alluding to during appellant's arguments, that is a level of trust that we put in the trial courts every day, being able to instruct a jury that they should consider evidence for one particular reason, or for character, or for impeachment, or for the fact of the matter. But even the Eighth Amendment recognized in United States v. Bolden in 2008 that the risk of improper spillover will be negligible if the jury is properly instructed.
I want to ask you something about a point you make in your brief.
Mhm.
You say that, I'm at page 19 of your brief, you say that precision liability is
Yes.
more important than accuracy reliability?
That's correct.
Right? And I assume you said that because it's important to your argument.
That's my second point, yes.
Let me give you a hypothetical. Assume that we have two hypotheticals, two capital cases with identical facts, okay?
Mhm.
And assume further that both of those cases, the facts in both of those cases, would lead to a conclusion of no death penalty, all right?
Okay.
Okay. So the best outcome there is both reliability and accuracy, right? Neither court imposes a death penalty.
Well,
right?
that assumes that the proper sentence there would be no death penalty.
That was built into my hypothetical.
That's correct, that's
Now,
correct.
let's go on. Now, let's change the hypothetical a little bit, okay? Assuming that it's not possible to make that assumption, okay?
Okay.
Shouldn't we prefer greater accuracy? That is, at least one court gets it right, then greater precision? That is, both impose the death penalty?
Well, Your Honor, the way that the Supreme Court has discussed the death penalty in the decisions that came down in the 1970s and the 1980s is to say that death penalty should not be handed down arbitrarily or
No, but what
capriciously.
about my hypothetical?
Right, and the way that the Supreme Court has answered your hypothetical is to say that we should let in as much information as
So
possible.
we would rather have juries uniformly wrong, that is, uniformly sentencing people to death who shouldn't be, right?
Well, that
Rather than inconsistency, but at least some juries getting it correct.
Well, Your Honor, that assumes that there is some accurate resolution of selection of a death sentence. The integral
Well, that was
to
built
the
into my hypothetical.
right, but integral into the nature of a death sentence is that it's given to the jury and it's supposed to be completely discretionary. And this is the jury passing a moral judgment on what the defendant has done. So this highlights great the difference between the logic that leads to guilt or innocence in trial
So-
versus a moral
Right.
decision in sentencing.
So the point you're making is what you say in the brief, which is with respect to accuracy, that's protected by the jury, right?
That's correct. And
But won't the jury do a better job of producing accurate results if it relies on accurate information? And isn't that what the Confrontation Clause is all about?
one could make that argument, but
I just did.
But right, exactly. But the Supreme Court has held exactly to the opposite. The way that the Supreme Court says that information should be handled with respect to giving it to a jury are that, so I'm quoting from Europe v. Texas in 1976, that the sentencing court should, quote, have before it all possible relevant information about the individual defendant whose fate it must determine. In Harris in 2002, the court said during sentencing, courts conduct, quote, an inquiry broad in scope, largely unlimited either as to the kind of
But it says
information they make.
I understand that. You make that argument in your brief, but take the affidavits in this case, okay? Take, for example, the neighbor, right? The neighbor says that he saw Draper beating his wife, right? He saw, and when he approached him, Draper raised his hand, telling him to move away, right?
That's correct.
Okay, well, imagine what a good cross-examination could do to that testimony.
Perhaps so, but
Well,
imagine
so that's
how
my
much
point.
more.
The answer isn't to have as much information, reliable or otherwise, before the jury. What's inherent in the court's decision is what we want juries to have is as much relevant, reliable information. It doesn't help anything to have the maximum amount of unreliable information before the jury.
And Your Honor,
And
we're not.
that's what the Confrontation Clause is all about.
Your Honor, we're not saying that wholesale bad evidence should be included, but
But
it's
that's
important.
what's happened with these two affidavits.
Right, what's the value of the jury knowing that this lady had bruises on 2 occasions? What's the value?
It speaks to the non-statutory aggravating factor of future dangerousness, and it's important.
Okay, but she might have fallen down the stairs, and yet the jury's allowed to take the fact that she's bruised
It may
to
very.
impose the death penalty, that she's bruised from falling down the stairs? I mean, isn't that what you're really arguing to us, that it's just so important to get these death penalty verdicts that we can take chances with the evidence?
Your Honor, the fact that the fact that you point out this possibility that there could be a different explanation shows how juries can make that determination too. And I see that my time's up. May I have leave to
answer the question.
that juries can make that determination too. These were affidavits, so these people didn't appear in court and have stronger testimony saying that in person. But the FDPA has in place.
But at least if the person had been there and had said in front of the jury, Draper raised his hand as if to strike her, he could have been cross-examined, and it might have been that what he raised his hand to do was to wave him off.
Perhaps if the Confrontation Clause applied at capital sentencing, that would be the case, Your Honor. But the fact of the matter is the appellant was tried, convicted, and ruled eligible for the death penalty without the testimony at issue. And it's for the foregoing reasons that the court should affirm the appellate's sentence. Neither Dr. Olson's testimony nor the affidavits admitted at sentencing violated his rights. Thank you.
You may argue in rebuttal.
Although, as opposing counsel noted, there are studies that indicate that patients do not necessarily consider the existence of privileges when deciding whether or not to confide in their therapist, not only are there studies to the contrary, but also, as Judge Tatel noted, arguing this point effectively argues the exact opposite conclusion found in Jaffe, and effectively would require that Jaffe be overruled. Because the Supreme Court in Jaffe based that decision on the idea that a privilege is necessary to induce and protect trust between patients and their therapists. Without this trust, patients, presumably, according to the court in Jaffe, will not confide in their therapists, and then society is worse off because people with mental health issues are not receiving the mental health help that they need.
Of course, we were doing fine pre-Jaffe, weren't we?
Well, Your Honor,
But do we have any evidence that things were a problem before Jaffe?
we do not necessarily have any evidence that people were avoiding therapy before Jaffe. However, we also don't necessarily know. It's not clear there was a split in the circuit courts at the time before Jaffe regarding the privilege. And so in certain areas, it would have been clear that there was no privilege, whereas in other areas, there was a privilege. And so to assess whether or not patients generally in the country were avoiding therapy would be difficult. But furthermore, as noted by opposing counsel, the idea that future protection for potential victims can be, in some cases, only achieved by imprisonment ignores the fact that civil commitment is there for exactly that purpose, and that's precisely why we believe that the footnote in Jaffe is merely making room for therapists covered by federal law to testify in civil commitment proceedings. And in
Doesn't
fact,
say that, though. That's your inference, right?
Your Honor, see how my time is
You may
expired.
answer the question.
That is our inference, Your Honor. However, that is supported by the fact that in the proposed Federal Rule of Evidence 504, which would have been a psychotherapist-patient privilege, there was an exception built in for therapists under federal law to testify at civil commitment proceedings. And that, we believe, indicates that the court was merely attempting to ensure that no one foreclosed that possibility present in that exception to the proposed rule.
Is your statement of the understanding of the footnote essential to your argument? In other words, do we have to think that that's exactly what the court had in mind for us to rule for you?
No, Your Honor, you don't. There are a number of interpretations of the footnote. It is, as noted by the Ninth Circuit, it is elliptical at best,
Right.
and there are a number of interpretations. However, we believe the interpretation that it creates a dangerous patient exception is by far the least natural of many readings. Thank you. And for the foregoing reasons, we request that you reverse the decision of the district court.
All right. Thank you very much. The bailiff may recess court.
All rise.
Well, we're certainly honored to be here with such good advocates. It's better than a lot that we hear on a daily basis sometimes. But I do want to announce to you the winning team and then the winning oralist, and then each judge will tell you any suggestions or ideas or comments or criticisms or commendations that they want to do. And so we have decided that the winning team, if I pronounce these names correctly, I hope so, Dan Gocek and Chris Cariello. The best oralist, we decided, was Lynzi Archibald. Now, I'll let our other judges tell us what your best ideas were. David, tell us yours. Any ideas about what you heard?
Well, first of all, let me say that I never did like Don Draper, but I never expected him to kill Betty. That wasn't in the show at all. Well, let me say a couple quick things. Number one, I thought the four of you just did a terrific job. You all understood the very basics of oral argument. They all knew their case, they knew the law, they knew the facts. They listened to the questions and answered them. Something that many lawyers who appear in courts of appeals never seem to get. They were able to answer questions that I think they had not anticipated. It was clear to me that the panel asked them questions that, although I'm sure they have argued this case before, they had not anticipated some of the questions. So overall, I thought you saw four extremely fine appellate advocates here. And generally, let me just say that, I think I've always thought that the ultimate achievement in the legal profession is arguing a case in a court of appeals. It requires all the skills you learn in law school, and the lawyers who appear before appellate courts, well, all lawyers in courts, but you particularly see it in appellate courts, like you saw today. The lawyer is really performing two roles. The lawyer is zealously defending his or her client, but the lawyer is also an officer of the court and trying to help the court make a decision. And what struck me about the four of you today is that most lawyers get the first, that is the zealous representation, but not all of them get the second. And I sensed in all four of the lawyers today that they understood that they were here not just to defend their client, but to help the court reach a proper decision. And that's a very sophisticated thing to say about appellate lawyers, and I congratulate the four of them for it. And finally, I'll say, most important, I hope the four of you had fun, because there's really nothing better than arguing a good case before an interested and well-prepared panel. And when you're done, you should say to yourself, that was really a lot of fun. So congratulations to all four of you.
Okay, Judge Keenan.
Right, I would like to echo Judge Tatel in saying you all did a wonderful job. I mean, it really is fantastic to come in here and forget for a minute that it isn't a real court with real parties arguing. I mean, that is the quality of what you put before us today. If I were to, or in giving some constructive suggestions, I think that if the slight departure from what the best lawyers do in the real world, slight departure here might be that you need to evaluate when you can argue a middle ground and still win your case, and maybe emphasize that more. An example being with the there is no dangerous patient exception. You don't have to argue completely against the exception, because you win anyway in the event that the court says that it applies only to cases where there's future harm. See what I'm saying? And you did allude to that, but to emphasize that to the court. In other words, a middle ground, and we still prevail. Because the larger context sometimes can be problematic for you. And by the same token, I would say to the appellees, emphasize that what you're arguing isn't really that extreme. Because when you start, talking, when both of you started talking in terms of the nuts and bolts, your arguments, I think, got a lot stronger. But when you were talking about the concepts of trying to essentially, in my view, convict these guilty people, I think it tended to sound extreme. So constantly ask yourself when you're arguing on behalf of the government, your case doesn't really go that far. What you're doing is practical, it's necessary, and it's still constitutional. So I guess what I'm maybe suggesting to both sides is to maybe tailor your arguments a little bit more to what would be palatable to the court. Courts generally don't like to do broad sweeping things. Well, I guess if you're the big Supremes, you do. But courts of appeal and other courts generally are incrementalists by nature and are cautious and careful. And I'm not suggesting the big Supremes aren't too. They're certainly cautious and careful, but are not necessarily as incremental in approach as courts of appeal. So if you're arguing a case to a court of appeals, look at how far you have to go to win, and maybe your case is stronger there. But that's a very, very small point that I'm making, because everybody was great, and it was a lot of fun to hear you. And you talk about suspend your disbelief. I suspended my disbelief, and I thought I was hearing some good lawyers arguing in front of me in regular court. So thank you.
Well, and I echo all of theirs, and I think it was great that you all, of course, been acquainted with these issues for some time, but it's great to have lawyers who will look us straight in the eye and answer questions, and you don't have to have notes, and it's good that you speak up. You have to remember, when you go to some of these appellate courts, some of the judges start getting hard of hearing, so make sure you speak up loudly enough for them, because we've had a few judges with us who have to ask the lawyers each time to speak up. But you did approach the case well, and they are issues that we may confront ourselves before too long. I haven't gotten any of these personally, but one of these days I very well may. But we thank you for your participation, and I know that it'll go with you throughout your lives. So with that, you may recess court, Mr. Bailey.
All rise.